Welcome back to our channel. Now we are discussing part 4 of this Amendment Act, Insolvency and Bankruptcy Code Amendment Act 2026. Now we are discussing on claims verification, cooperation, Committee of Creditors and liquidation supervision. The first question, this is FAQ model. What changes have been made to section 18 regarding the duties of the interim resolution professional? Section 18 of the Insolvency and Bankruptcy Code specifies the duties of a IRP, interim resolution professional. The 2026 amendment, this strengthens the claim verification, the process by introducing a greater clarity regarding the responsibilities of the IRP. Earlier, the IRP was required to collect and collate the claims submitted by the creditors. The amendment now expressly provides that claims shall be submitted in the manner specified by the IBBA. The IRP must verify every claim received. Wherever necessary, the IRP is empowered to determine the value of the verified claims. This amendment enhances the transparency and ensures that only verified claims are considered during the corporate insolvency resolution process. Why has the government empowered the IRP to verify and determine claims? One of the recurring challenges during CIRP has been disputes regarding the correctness and valuation of the claims filed by the creditors. So the amendment seeks to address these issues by expressly empowering IRP to verify documents submitted by the creditors, examine supporting evidences, seek additional information wherever required, determine the amount of admissible claims, so reject unsupported or inflated claims. Here the practical benefits are it prevents the fictitious claims, reduces the disputes before the Committee of Creditors, and ensures the accurate voting shares, and also facilitates fair distribution during resolution or dissolution. This amendment therefore improves the reliability of the insolvency process. What important amendments have been made to section 19 relating to cooperation with the resolution professional? Here, section 19 have undergone significant changes, widen the scope of persons obligated to cooperate with the insolvency professional. The amendment replaces the earlier expression, that is personal of the corporate debtor, with the broader term persons. The following persons are now specifically required to extend full assistance and cooperation: existing employees, former employees, directors, promoters, persons associated with the management, and individuals engaged under contract for service. Any other person covered by section 19. So this significantly expands the responsibility to assist the interim resolution professional. Why has section 19 been expanded? The answer is several insolvency proceedings, if you see, promoters and key managerial personnel resigned immediately before commencement of CIRP and says that they claim that they are no longer obligated to cooperate. So the amendment removes that loophole. Even former personnel and persons previously associated with the management continue to have a statutory obligation to cooperate with the interim resolution professional, and whenever their assistance is required. So this helps the resolution professional obtain books of accounts, financial records, bank information, contracts, statutory registers, and even pending litigation details. So the amendment therefore strengthens the investigation and asset preservation. What happens if a person refuses cooperate with the interim resolution professional? So where any person covered under section 19 fails to cooperate with the interim resolution professional may approach the adjudicating authority. The NCLT may issue appropriate directions requiring such person to produce records, hand over assets, provide explanations. So failure to comply with the directions of the adjudicating authority may attract legal consequences under Insolvency and Bankruptcy Code. The amendment ensures that insolvency proceedings are not obstructed by non-cooperation. And what major amendment been introduced regarding the Committee of Creditors during liquidation? One of the most important reforms introduced by the Amendment Act is the continued role of the Committee of Creditors even after the commencement of liquidation. Section 21, subsection 11 has been inserted. Earlier, once the liquidation commenced, the Committee of Creditors practically ceased to exist. Now, the amendment provides that the Committee of Creditors shall supervise and conduct the liquidation process. Liquidator shall function under the overall supervision of the CoC. Meetings may continue during the liquidation. Certain class of creditors may attend the meeting without voting rights if specified by the IBBA. So this represents a major policy shift in insolvency law. So why has the Committee of Creditors been retained during the liquidation? The government recognized that the creditors have the maximum financial stake in the liquidation. Accordingly, the continuing the Committee of Creditors during liquidation provides several advantages like a better monitoring of liquidation and greater accountability of the liquidator, improved transparency and faster decision making, and better realization of the assets, and increased confidence among the stakeholders. Instead of functioning independently, the liquidator will now remain accountable to the Committee of Creditors throughout the liquidation process. Will the amendment provisions regarding the Committee of Creditors apply to pending liquidation process? The answer is yes, subject to certain conditions. The amendment specifically provides that the new provisions relating to the Committee of Creditors during liquidation shall apply to all the liquidation proceedings commenced after the amendment comes into force. So, ongoing liquidation proceedings wherever the liquidator has not yet filed an application for dissolution under section 54. Accordingly, many ongoing liquidation proceedings may also governed by the amended provisions. So what amendment has been made to section 22? This is relating to appointment of resolution professional. Section 22 deals with the confirmation or replacement of the interim resolution professional by the Committee of Creditors. The amendment provides that where the Committee of Creditors resolve to appoint an interim resolution professional as the resolution professional, the appointment shall become effective from the date of the CoC resolution itself. The decision is to be communicated to the interim resolution professional, corporate data, and Insolvency Bankruptcy Board of India. So earlier communication was required to the adjudicating authority. The amendment reduces the procedural delays and ensures continuity of the insolvency process. What changes have been introduced to section 25 regarding the duties of the resolution professional? Section 25 specifies the duties of the resolution professional during the CIRP. So the amendment revises the section 25 subsection 2J to provide the resolution professional shall file applications before adjudicating authority in respect of avoidance of transactions, fraudulent wrongful trade avoidance, and fraudulent or wrongful trading. This amendment expressly includes fraudulent and wrongful trading. So this is these proceedings with the insolvency. See here, if you see the scope, the professional RP shall file the applications before adjudicating authority in respect of the avoidance of transactions, fraudulent transactions, or wrongful trading. So this amendment expressly includes fraudulent or wrongful trading proceedings with the statutory authorities. So the responsibilities of the resolution professional, increasing the responsibilities of the resolution professional. The objective is to maximize recoveries for creditors and discourage misconduct by promoters and the management. Another question, how will these amendments benefit stakeholders? For example, financial creditors, better verification of claims, that is an advantage, and accurate voting rights in CoC, and greater supervision during the liquidation, that is an advantage. Even for operational creditors, fair determination of claims, increased transparency. Even for resolution professionals, it's a clear statutory power for claim verification and better authority to obtain cooperation. This is another advantage. And defined responsibility to pursue avoidance and fraudulent trading transactions. Even for liquidators, better guidance through continued CoC supervision and improved stakeholder participation. And even for corporate debtors, more transparent process, efficient administration, better coordination with the stakeholders. So the key takeaways, we can say the amendments overall covered in this part significantly they strengthen the institutional framework of the insolvency process. IRP has now express powers to verify and value the claims. Obligation to cooperate extends beyond current employees to perform personnel, promoters and management. The Committee of Creditors continue to function during the liquidation. The liquidator is subject to supervision of CoC, and appointment of resolution professional becomes effective immediately upon CoC approval. Resolution professionals are avoidance and fraudulent trading applications they will pursue. These reforms improve the accuracy, accountability, transparency and creditor confidence while ensuring the liquidation is conducted in a more structured and commercially efficient manner. So we'll meet in part 5. Thank you.